All rise. First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have one case on our docket this afternoon, case number 223284, SEI Fuel Services versus the Florida Department of Revenue. Appellant's counsel, when you're ready.
Good afternoon, Your Honor. May it please the Court, Michael Bowen for SEI Fuel Services, Inc. I'd like to reserve 5 minutes for rebuttal.
Noted.
The facts of this case are straightforward and not in dispute. SEIF is a Florida licensed supplier of motor fuel. SEIF supplies fuel to 7-Eleven gas stations throughout Florida. During the relevant period, SEIF purchased motor fuel from Sunshine Gasoline Distributors, Inc., also a Florida licensed supplier of motor fuel. SEIF erroneously paid over $3 million of motor fuel tax to Sunshine relating to certain purchases of motor fuel. Sunshine collected, reported, and remitted that tax to the Department of Revenue. Sunshine's filed fuel tax returns with the Department of Revenue reflected this payment of fuel tax. When SEIF later supplied that motor fuel to 7-Eleven gas stations in Florida, it also reported and remitted that same $3 million in fuel tax to the department. SEIF's filed fuel tax returns with the department reflected this payment of tax to the department. So in all, the department received $6,359,350.22 in fuel tax when the correct amount of fuel tax due and owing on the purchased fuel was only $3,179,675.11.
So we understand that that SEI paid $6 million through different channels, $3 million through two different channels to the Department of Revenue. The Department of Revenue collected $6 million on a certain set or a certain discrete volume of motor fuel. It seems from the statute that the part of those taxes paid through the supplier to the Department of Revenue is barred from refund or credit. Do you agree?
Well, we disagree as to an interpretation of the statute. We filed a refund claim with the Department of Revenue seeking a refund under 21526, alleging that there was an overpayment of tax. Notably, we paid tax, SEIF paid tax through Sunshine. Sunshine's a collection agent for the Department of Revenue of the fuel tax that we paid to it, reported on its return to the department. And we also paid the department the same tax. These facts are not disputed. Mm-hmm. So there was a double.
Is your refund claim, though, predicated on going through a certain channel, recovering one or the other payments?
It is, Your Honor.
Is it fungible and it doesn't, you're going after both?
No, it is, Your Honor. It's 21526 only permits the payor of the tax to seek a refund. And in this case, that would be SEIF. When we filed our returns with the department, that we are seeking that refund. The department has acknowledged this before the administrative law judge, stating that what SEIF is seeking is its payment of tax to the department. We're not seeking, nor could we seek, Judge Osterhaus, the other payment, because at the end of the day, Sunshine filed those returns. If any credit or refund was going to be given, Sunshine would have to seek that credit or refund. We could not seek that refund. Although we paid that tax through them to get to the Department of Revenue, they're ultimately the ones that remitted it and paid the tax to the Department of Revenue.
Could we back up a little bit? Let's just start with what type of supplier your client is. Under the applicable statutes, weren't they required to directly pay the Department of Revenue? Wasn't that a proper payment? Assuming the other wrong payment hadn't occurred, was that a correct payment?
It was a correct payment.
And it was a payment that was due and owing under the law, right? It wasn't an overpayment. It was a payment that was due.
That payment was due, correct.
Right. So the erroneous payment is not the one that you challenged before the hearing officer, correct? You didn't seek a refund of that, and I want to point you to the statutory language. There shall be no credit or refund for any of the taxes imposed by 20641D, et cetera. Is the mistaken payment to Sunshine a tax imposed under 206?
One more time, Your Honor, is the tax paid to Sunshine?
Is the tax that was erroneously paid to your client supplier, is that a tax within the definition of 206414 subsection 3?
Yes.
It is. Well, I mean, because you're also arguing that it was mistakenly paid. It was never owed, right?
It was never owed.
Right. So is it in fact a tax under the definition of the statute?
It depends how we read that. I mean, they invoiced us for the tax assuming it was based on those subsections, right? They assumed that it was, and we assumed that it was as well. And we paid them that tax pursuant to those statutes. It was an erroneous payment.
But that's where your dispute is, and I guess that's my point, is the other payment, the direct payment from your client to the Department of Revenue was due and owing, it was proper, and it was properly paid to DOR. But that's the one you're challenging, correct? That's one you challenged below before the hearing officer.
SEIF's payment to the department, correct.
All right.
Can I follow up on Judge Roy's citation to 206-4143? The last sentence there, no credit or refund for any taxes imposed above the minimum established in this section paid by a terminal supplier, so you're a terminal supplier, a wholesaler, you're a wholesaler, or an importer to any supplier. You're not an importer. Does that to any supplier only modify importer? Wouldn't that be that last antecedent doctrine would say that to any supplier only modifies importer? You're the way that I understand you and maybe the department are reading this is in the section paid to any supplier by a terminal supplier, wholesaler, or importer, period. But that's not actually how the text reads. That's
an interesting read, Your Honor. I don't think either side has interpreted it that way.
Wouldn't the last antecedent doctrine of interpretation say that we should interpret it that way?
So how would that play out in this inspection?
Well, that's what I'm asking
you.
Yeah,
I'm not sure how that would play out in this circuit, because as we read it, and I think the department reads it the same way, is that in the section paid by a terminal supplier, which would be us,
right.
SEIF, wholesaler or importer, to any supplier. That to any supplier, I think both sides would say that's Sunshine in this case. They are the supplier.
If to any supplier modifies terminal supplier and wholesaler, then correct. But if to any supplier only modifies importer and you're not an importer, what would the effect of that be?
206-414 wouldn't apply at all.
Wouldn't apply.
Our situation would be outside the scope. 216-414. I don't think either side has considered that argument, Judge Bilber. That's an interesting interpretation, for sure.
Well, and certainly, didn't you had an ability, your client had an ability to not just seek relief under 120 for the mistaken overpayment, but you could have gone to circuit court under 72011, right, to seek a judicial determination as the propriety or the legality of that payment that you made to the supplier. But that didn't happen, right?
That's correct.
And there's nothing in the record that suggests that your client has tried to get that $3 million back to the person it paid, Sunshine, right?
Correct.
Nothing in the record on that.
Correct.
Okay.
What is in the record, though, Judge Rowe, is the department's concession that Sunshine is somehow entitled to a credit. And we've cited this in our reply brief and cited to the record where the department somehow has acknowledged that Sunshine, despite the language how they interpret 206.414, is entitled to a credit of the same $3 million that they're telling us that we're not entitled to. So the department's interpretation of 206.414 is that no one is entitled to a refund or credit based on those payments from one supplier to another supplier. Yet, they told the ALJ repeatedly, as we quote in our reply brief, that somehow Sunshine is entitled to that credit. They have not explained how Sunshine is entitled to that credit, but they have repeatedly stated that Sunshine is. Sunshine has applied for that credit, and that credit is currently pending, waiting resolution of this case.
Right, and certainly, let's assume they got that credit, right? In terms of good business, your client would be entitled to that, would have some claim to it. And that's one of those questions that we often ask at the appellate court is, what happened below? What are we looking at? And the genesis of this dispute is a mistaken payment to the supplier that has been unchallenged below.
The mistaken payment to
The mistaken payment that your client made to Sunshine has not been challenged, right? That there's been no challenge to that. There's been no circuit court action or 120 proceeding to try to recover that payment.
We could not do that, Your Honor. 7-Eleven.
Well, that's your argument, but certainly you didn't do that, right?
No, procedurally, we could not. I mean, we're not the ones, it's almost like when you go to pay sales and use sales tax at a store. If you pay sales tax at the store and they pay that on their sales tax return and you decide that you weren't responsible for that tax, you couldn't go to the department and ask for that tax back. You didn't remit the tax. It's the same thing here with the fuel tax. Sunshine remitted that tax that we paid Ed. We can't ask for that money back, not from the department, because we paid the tax to them that they paid to the department. They filed a return that could be audited potentially, that shows the transactions that were paid on and so forth. So we couldn't have challenged that payment and sought that relief. I would have to reserve the balance of my time unless there are any further questions. You look like you're very pensive and you want to be.
Thank you.
Yep.
May it please the court, Timothy Dennis, Office of the Attorney General for the appellee, Florida Department of Revenue. The department's under an unambiguous statute, Section 206-414, that requires SEIF to remit the tax, directs SEIF not to pay the tax to its suppliers, and expressly prohibits the department from issuing a refund to SEIF if it does. To your question about the last antecedent, Judge Bilbrey, I think if you were to look at that and apply the doctrine of the last antecedent, then it would simply say there shall be no credit or refund for any of the taxes imposed by Section 206-41D and F above the annual minimum applied in this section. And so the result would be the same, that they would not be entitled to the refund.
Well, and maybe you can answer the question I posed to the appellant. I mean, let's look at all of the language. Given that I think all the parties agree that this payment should never have been made to Sunshine, is that correct?
Correct.
Right? So that's stipulated. Given that it should never have been paid, in fact, as you mentioned, 206-414 says it shall not be paid, right? Shall not, prohibited to be paid. Then the next sentence discusses that there shall be no credit or refund for any of the taxes imposed by 206-41D. Isn't there an argument that a tax that could never have been paid by the terminal supplier is not a tax imposed by 206-41D?
Your Honor, I think the fact that this is not in the briefs, but I think any monies that are collected as tax are for legal purposes, taxes for purposes of the record. And no party has argued that this wasn't a mistaken tax payment. I think it was a payment of taxes. And this argument that there's somehow some remedy available is just not in line with what the statute provides.
But you would agree, I'm sorry, that if 206-4143 doesn't apply, then 215-261 would say that they get a refund?
Well, certainly our position is there's a clear expression of legislative intent here that that there are to be no refunds for when these taxes are remitted to between suppliers. And perhaps that might be the case, but I think it's a stretch to say that they weren't taxes. I mean, they were invoiced, they were discovered by the department during an audit. The appellant concedes that it was a mistaken dual.
And
payment.
I think I'm getting at, in terms of what remedy may have been available. Again, if it's a tax that could not have been paid by the payor, then how is it a tax that is actually imposed under that statute? So that, again, I'm acknowledging none of that was tried below, that wasn't brought before the hearing officer at the department, but certainly, the crux of the problem and why we're here with a double payment of $3 million is because there's nothing in the record as to seeking relief on the mistaken payment as opposed to the proper payment.
Well, I think that goes to, as Mr. Bowen alluded to, and the department did below acknowledge that perhaps Sunshine may have had some remedies with the department, and that's correct, but his argument's a bit of a straw man, and maybe we just weren't clear.
Well, does that comport with your reading of the statute, though? I understand your reading of the statute is basically payments that went through that channel. There can't be a refund or credit.
Well, and that's what first, right, let's all acknowledge, Sunshine never intervened in the proceeding below, and they clearly weren't a party, and that this discussion about what their remedies, might be, or that they might have, or is really sort of off track. I mean, what we really need to focus on is what's before the court today, which is Sunshine's refund claim and the department's denial. But I think if you look at, more importantly, though, if you look at 206-414-2, it prohibits terminal suppliers and wholesalers from collecting the fuel taxes at issue. Right, but it doesn't contain a similar prohibition on a refund claim or a credit. Now, I am not conceding that Sunshine at this juncture, at this stage, is necessarily entitled to a refund or a credit, but at least during the proceedings below, we did acknowledge that there was possibility that they could apply for it.
So where that leaves us is the department has collected $6 million on a $3 million tax bill. And it's saying they can't give it back through channel, they can't get back the $3 million, overpayment, or whatever you want to call it, through that channel. And it won't give it back, or the law prohibits it, or your argument today is you won't give it back through the direct channel either, which leaves the department double collecting on a tax for a specific volume of motor fuel when everyone agrees that you're holding double the money that you should be, and that money came from SEI.
Well, Your Honor, I think that's an important word, double the money you should be. I mean, this goes to their argument about windfall, right? They're saying, no, there's this big windfall to the state. Well, first,
or overpayment or error. I mean, who gives $6 million on a $3 million tax bill?
Sure. The legislature clearly passed a prohibition that says, look, if you overpay these taxes to a supplier, there is no refund available. The legislature certainly must have considered the risk that there was some overpayments. And that goes back to our citations in our brief to State versus Victor Chemical Works and Bank of America, which is an opinion from this court. If there's a statute, unless there's a statutory basis for a refund, it's constitutionally permissible, I guess, for the state to say there is no refund for taxes voluntarily, although erroneously paid.
But I think that goes to, again, the language I keep pointing you back to, which you're reading completely out of the statute, which is the refund for or credit for taxes imposed under those provisions. So if I accidentally send you my income tax, payment and label it, payable to the department, and I happen to be a terminal supplier, the Department of Revenue doesn't just get to keep it. It has to be a tax that's imposed under 206-41D or E or F, right? That's what the limitation is it not?
I think, Your Honor, that if you read the statute as a whole, and although there is limited legislative intent in the record, it is limited. I think what the conclusion that you come to is the legislature was making the suppliers and wholesalers their own insurers to ensure that this doesn't happen, and the remedies were to be worked out between those sorts of entities. We're talking a lot of transactions. I mean, and, you know, millions of transactions and millions of dollars. And I know that, you know, it sounds like, wow, this is, you know, maybe really inequitable or whatever, but SEIF didn't notice it for, you know, until they were audited by the
Sure.
department several years
So
later.
let's stop right there. What's the limiting principle? What if it had been $100 million that they had
Sure.
paid? Is at what point? I mean, under your reading of the statute, some accountant in the office might add an extra zero, and so instead of a $10 million payment, they make a $100 million payment. And your reading of the statute is no refund, no credit. The department, the state keeps $90 million.
Well, so, I mean, there is no, you know, constitutional claim here. I mean, you mentioned there was no resort to circuit court. This strictly went through DOA. And so looking at the statute, I mean, we're a creature of statute, and the department is a creature of statute. And they put limits all the time. I mean, there's a statute of non-claim for refunds. There's a statute of limitations for collecting tax. Sometimes the department, an audit discovers taxes that were owed that weren't paid, but it can't pursue those because of the statute of limitations, for example.
So the answer is you'd keep the $100 million, right?
Under the circumstances of this case, I think that is the answer. But, you know, it goes.
Why can't we call it an overpayment or an error?
I think, Your Honor, the department's position is very simple, because 206-4141C puts the legal obligation of paying the tax upon SEIF.
Well, and they made a payment directly that could be construed as an overpayment because it made you have, it resulted in you collecting $3 million too much, or an error because that money had already, that bill had already been satisfied.
The department's view, Your Honor, is that the legislature set forth a clear prohibition on refunds for the, you know, for payments made, for duplicative payments or any payments made to suppliers as taxes.
But that's only half of the amount we're talking about. I was talking about the other half. The other half was a direct payment.
Right.
That was made
Right.
as an
So the
overpayment or
other
an error
half-
because that bill had already been satisfied.
Your Honor, in the department's view, it's barred from giving that because the legal incidence of the paying that tax is on SEIF.
Would the result be different if they would have sent you two $3 million checks directly?
In that case, yes, I believe so.
You would have given them $3 million.
The department.
Yeah, the
I
department.
mean,
I understand.
hypothetically speaking,
Sorry.
that would probably be, then you would not be looking at 206-4143. So I've just got a few minutes left. There's just a couple of other points I'd like to make. I mean, there is, again, there was limited legislative history regarding this case, but it's certain that they were trying to prohibit a certain consequence, and the appellants come forward and said, look, you know, there's no fraud, this was a good faith payment, you know, and really these arguments are equitable. I mean, really at the end of the day, what SEIF is doing is asking this court to grant it equitable relief and indemnify it for its business mistakes. And equity requires clean hands. Clearly, SEIF.
So it's a mistake, but it's not an error.
In the department's view, SEF, they violated the law, Your Honor, 206-4143. And so it is a criminal, but there is a penalty. The legislature set forth the penalty, no refunds. So we would respectfully ask that you affirm the department's final order. Thank you.
Thank you.
I have a couple points I'd like to try and get through in the next 5 minutes. The first is regarding the statute and its ambiguity or clarity. I think Judge Bilbrey came up with an interesting read of it that the parties hadn't considered, and Judge Rowe came up with an interesting, reasonable interpretation of the statute that the parties hadn't considered in this case. And again, the department has not explained under its interpretation of 206.414 how Sunshine is somehow entitled to a credit in light of its interpretation of that particular statutory language. In light of that, the legislative history, I think, is important. And as we cite in our brief, the reason why the change came about in 1995 was because prior to 1995, the Sunshines of the world had the ability to collect, remit, and pay to the department tax prepaid, as received from SEIF, for example, in this case. So there were multiple payors potentially the same tax. The reason why this change came in 1995 was to restrict the ability to get credits and refunds in those circumstances. And SEIF's interpretation is that the changes to the statute in 1995 prevents Sunshine from getting credits and refunds because they are the payors on that return. They file the return with that alleged illegal payment on it. And in 1995, the legislature said, okay, fine, from now on, Sunshines of the world, your distributors are not entitled to get refunds. Only the payor, only SEIF is entitled to get the refunds under 215-26. That's the only route, and that's how SEIF interprets 206.414 and the legislative history relating in 1995. Your Honor, I think it's really important in light of where we are here that we think about the Kemper case, and that's a case of this court, relatively recent case in this court, where the statute was, again, if strictly applied, would have generated a windfall for the state, multi-million-dollar windfall. And in that case, this court said, we're not going to interpret the statute in a way to penalize a taxpayer for a good faith effort in order to meet its tax obligations. Here, sure, we made an erroneous payment to Sunshine, but it's not as if we're trying to evade tax. There's no fraud here. There's nothing been alleged. It's not as if we never paid it and we're seeking a refund of something we didn't pay. We paid twice. And we believe that the Kemper case lends support for this court's decision in Kemper, lends support to our refund claim here. There was simply an error, simply a good faith mistake, that if you interpret the statute according to the department's interpretation, we are penalized in light of a good faith mistake that multiple parties here involved didn't pick up on. The department didn't pick up on it, apparently. Sunshine didn't pick up on it, apparently. And SEIF, for various reasons, didn't pick up on it until SEIF was audited.
Should we apply Kemper, though, if we were to find that there was another available path for you to recover this money?
I would love to understand what that path would be. As I've indicated to your previous question earlier, Judge Rowe, there's no ability for SEIF to get a refund of the amounts that we paid through Sunshine because Sunshine filed that return. There's no procedural route for us to get that. Sure, as you've indicated previously, we could have filed in circuit court, but that, again, we would have filed in circuit court based on our refund claim. Our refund claim was our attempt to get the amounts that we paid to the department back because that's the only money that we're tied to the department. Now, indirectly through Sunshine, we wouldn't be able to get that money back. We wouldn't be able to sue. There's no cause of action to get that money back.
And I don't think my question was directed only at legal action. So I think that's part of the question that's being asked here.
We couldn't file a refund claim either, pursue that because we ultimately paid the refund paid the tax through the collection agent, which was Sunshine. They would need to file their refund claim, which in this case, as you know from the history of this case, they sought. They're actually pursuing it now, but they're being held in abeyance pending resolution of this case because we believe someone's entitled to it. And the department seems to believe that Sunshine is potentially entitled to it, but they're telling us that we're not.
If we agree with you that you're entitled to a refund under 215-26, what do we do about the limitation period in 215-262 on the 3 years? Do we kick it back for further proceedings on that, or are you looking for us to just say DOR write a $3 million check? I mean, How does that factor in?
That comes into play, that's the timing of the refund claim. So as long as we filed the refund claim within the 3-year period, which we did, we filed the refund claim in this case within the period of statute of limitations as provided.
Some of the claim goes back to 2011, right, for payments in 2011. And I don't have the exact date in front of me, but I thought it was around 2019 that you sought the refund. So that's more than 3 years, right?
Well, the refund period, the statute of limitations is held open during audit. So here, we were audited for 11 through 14. The audit period continued to go. You signed statute of limitations waivers. It continues to get waived. There's been no allegation. Everyone acknowledges that we're timely with respect to the refund claim here.
Thank you.
Thank you.
Thank you, counsel. That is the only case that we have on our docket this afternoon. But before we adjourn, we wanted to welcome the Tallahassee Newcomers Club to our court this afternoon. It's wonderful to have you here, and we thought that we would open the floor to you all. If you have any questions of us about how we do things, we can't talk about this case or what we think about it or any of the arguments or critiquing counsel or judges, and let's stay away from that. But if you have questions about what we do here and questions about the building or what have you, we'd love to hear them. Yes. Yes. It probably happens a little bit more quickly on TV, the 30 minutes that they allot or what have you. That's it. That's it. But we'll take that as a compliment. Thank you. Judge Thomas.
I kind of gave them a preface about the court before we came in, so that's probably our address. That's probably why they're really quiet. It might be interesting to hear from you. I told them coming in, I said, it's bad to be in the hot seat as the litigants. That's the hardest job to come in here to do. So that's always a lot of hard work goes into all of it.
Yeah, absolutely. I think all of us up here have been in that seat and at that podium. And those days when you have oral argument are nerve-wracking. You prepare a whole lot, and I used to get friends to ask me really hard questions in preparation so that I could be ready for what the judges might throw at me. And you never quite know what you're going to get when you're standing up there, but preparation really helps. Yes.
Is that true of the judges too? You never quite know where you're going to get. You're very prepared.
It can be, yes. We do prepare a good bit for each argument, and I'll let my colleagues speak also. And it's a different role because, in a sense, the judges are forcing the action are the questioners, and they don't have to be on the hot seat anticipating what types of questions they'll get. So it's a little different, but it is a dynamic process because you don't know what answers you're going to get and what rabbit trails that might lead to or what have you. But let me throw it up. And let me just introduce myself. My name is Tim Osterhaus. I've been on the court here for a little over 10 years. I was appointed by Governor Rick Scott in 2013. And let me throw it over to Judge Rowe and for maybe a little introduction, and she can comment on any of that too.
Sure. My name's Lori Rowe. I've been on the court since